Good afternoon, Judge Barrows.
Good afternoon.
Welcome.
Thank you.
I'd invite you to get comfortable there in that chair, and when you are ready, you may begin with your opening statement.
I will. A little bit of deja vu. Well, good afternoon, and I want to thank you, Ms. Roberts, and the members of the Commission for serving in this capacity. You've given considerable time and energy to this very important task. Your efforts are essential to ensure that Iowa has a fair and independent judiciary. A little bit about me. I'm proud to be a small-town Iowan, raised by small-town Iowans. I grew up in Fawlitz and Comanche in Clinton County. Most of my family still lives in that area, and I currently serve as the Clinton County liaison judge. My parents were children of the Depression who worked hard and eventually built a successful family business. I am the first in my family to go to college, conscious of the sacrifices of those who made that possible. All of this informs my character and fuels my work ethic. If fortunate enough to be appointed, I hope to take what I've learned to the Iowa Supreme Court. I'm married. My wife Karen is an attorney for the United States Army. I have two children, Ellie, age 12, and Max, age 11, who are the inspiration for much of what I do and hope to accomplish. Of course, there are two questions most asked when one applies for this position. Why do you want the job, and how would your appointment enhance the court? I'll try to address both of those. My reasons for applying are to deal with the important and cutting-edge issues that come before the court. I think that is something that appeals to almost all of us who do this work. In my case, that would be particularly true of the cyber and electronic evidence issues that loom on the court's horizon, both in the civil and criminal contexts. To work toward improving the system of justice on a statewide basis, including access to justice issues. I believe that a district court judge's experience dealing with pro se litigants is particularly critical on this point. To advocate for specialty courts, such as drug court and mental health court, a cost-effective and humane way to deal with many nonviolent offenders whose crimes are driven by addiction and/or mental illness. It is, of course, the Supreme Court that administers the district courts. It is my strong belief that the court needs additional members with district court experience to more effectively do so. The court is now down to only one member with significant district court experience, a situation that would have been considered unthinkable during most of the court's history. And on a more personal level, to make my family proud and to set an example for my children, showing them what is possible through hard work and determination. Now, how would my appointment enhance the court? First of all, I just want to state that we have a Supreme Court comprised of exceptionally gifted individuals who are obviously capable of figuring out most things on their own. I simply look at the collective knowledge base of the court to see where there are areas in which I might be of assistance. Nobody has experience with everything, particularly in this age of specialization. My belief is that the court should work together in a collegial fashion, drawing on the varied backgrounds of its members, and these are the areas in which I think I could help. I've handled cases of considerable complexity, including numerous highly sophisticated criminal prosecutions in the challenging environment of federal court. I do believe that the Supreme Court could benefit from the perspective of someone with this type of extensive criminal experience. After all, an enormous percentage of their caseload consists of direct criminal appeals and post-conviction relief actions dealing with criminal law issues. At present, there is very limited criminal experience among the members of the court. In fact, 4 decisions came out this morning, and 3 of those involved criminal law. I was both the computer hacking and intellectual property, or CHIP coordinator, and Project Safe Childhood coordinator for the Southern District of Iowa. This afforded me the opportunity to become trained in and experienced with cutting-edge issues of electronic evidence and computer forensics, including the complicated topic of privacy in the age of the internet. In both capacities, I received specialized and sophisticated training at the National Advocacy Center in Columbia, South Carolina, as well as at numerous additional conferences around the country. To give you an idea, the CHIP coordinators were the individuals in the various United States attorneys' offices who were responsible for the nation's most complex cases in areas such as cyber intrusion and DDoS attacks. They also grappled with exceptionally challenging issues involving electronic evidence, including its acquisition and use. I personally have litigated numerous cases that involve the introduction of complicated computer-based evidence, including the digital trail that evidence left as it bounced around servers in the United States and sometimes around the globe. This training and experience would be valuable to the court as it continues to grapple with these issues. Just a few examples of what the court might confront in these areas would be the following. What metadata is covered by the discovery process? What cell phone tracking data will require a warrant? What is the reasonable expectation of privacy in the wide variety of digital information shared with or otherwise provided to app developers or social media platforms? What type of process is required to secure various types of digital information from internet service providers, app developers, and other third parties? What is the evidentiary value of data found in the unallocated space of a computer? What foundation is necessary to admit various types of digital evidence at trial? And what about biometric data? At what point, if any, is it considered testimonial evidence subject to the protections of the Fifth Amendment? These are examples of dozens of such issues that the court will face. Now, this is not to suggest that I would come to the court claiming to have all of the answers to these questions. I simply suggest that at present I see no one on the court with this type of expertise. Given that, I believe that my training and experience would be particularly helpful to the court as a group in understanding those issues. I was the drug court judge in the 7th Judicial District with my 2-year rotation ending in January of 2019. This was a profound experience that gave me insight into the challenges faced by those in our criminal justice system who struggle to break the grip of addiction as they attempt to rehabilitate their lives. This has informed me as a district court judge and would continue to do so if I were fortunate enough to be appointed to the Supreme Court. Additionally, the state has recently received a federal grant to aid the judicial branch in its support and assessment of drug court programs. I'm not aware that any member of the court has supervised one of these specialty courts. As such, I think my experience in this area would be particularly beneficial. My experience as a writer, appellate advocate, and judge has given me the ability to craft opinions in a useful, clear, and concise manner. I think this is tremendously important to making the court's rulings more accessible and helpful to the public, practitioners, and judges. I've never been on the 60-day list. If that time frame were shortened to 10 days, I would still never be on the list. In fact, a few weeks is the longest it ever took me to produce a decision. And that was after a week-long bench trial involving numerous complex business and employment law issues. I normally have my decisions out in 1 or 2 days. I know that my chief judge and district court administrator would both tell you that I am one of the most efficient individuals in the 7th Judicial District, always willing to cover another county on short notice and willing to fill in on a case when someone calls in sick or has a conflict. I routinely work the EDMS queue on my own without being asked to help out the administrative judge or take other random assignments to assist my colleagues. Finally, I believe that I've demonstrated a patient, thoughtful judicial temperament while on the bench, a strong work ethic, and a firm grasp of the issues. I make certain that litigants have been heard and that they feel that they have been heard. My many and varied life experiences leave me quite conscious of the frailty of the human condition. I have an appreciation for people from all walks of life, and that is something I would hope to bring to the Iowa Supreme Court. Thank you for your consideration.
Thank you, Judge Barrows. And we will begin with questions at this time, and we'll begin with Ms. Stanger.
Thank you, Madam Chairwoman. Good afternoon, Judge.
Good afternoon.
Thank you for reapplying. It's great to see you again. We've heard today that we need district court judge experience on the Supreme Court. and there are a few district court judges that are being considered by the commissioners.
Mhm.
What is it that distinguishes your experience, or you in particular, among the others for the nomination today?
Well, I can't say that I've parsed everyone's application in great detail. I think the things that distinguish me are probably the things that I mentioned here. The extensive criminal law experience, which I think is pretty sophisticated and I think somewhat unique among the applicants. Certainly my cybercrime and electronic evidence experience is unique among the applicants. I'm not aware that anyone else that's applied has supervised a specialty court. Obviously, I feel that those are very important, and I think to help expand specialty courts in Iowa and to understand fully what's needed to do that, you need to know how they work, and you need to know how the participants in that program respond and what they need going forward. So I would say that those would be some particular areas that might distinguish me from the other district court judges.
Thank you.
Thank you.
Ms. Pearson?
No question.
Mr. Gray?
Thank you, Madam Chairwoman. Judge, you talked about the need for an independent judiciary. Could you tell us what you mean by independent judiciary and why that's important?
Well, the judiciary should always be independent. It's been independent through our history. I think that there has to be a concern that you pick judges who are qualified, who have an appropriate temperament, and don't come to the job with a particular agenda. I think it's okay to have a judicial philosophy, but it's not okay to have a particular agenda. I hope that answers your question.
I wondered if you meant perhaps independent of the executive branch or the legislative branch.
Oh, yes, of course.
Thank you.
Mr. Hoytik?
Judge, with your background as a prosecutor, can you speak to what would give a defense attorney or a defendant comfort that perhaps you'd be able to come to this position, seeing both sides?
Well, one of them that I had many cases with is in fact in the room, and he can speak to that. And I think Mr. Spies would.
He didn't put me up to it, by the way.
I think Mr. Spies would tell you that I was very reasonable in carrying out my duties as an assistant U.S. attorney. This is a discussion that was had when I took over drug court, because when the drug court participants found out that a former federal prosecutor was going to take it over, there was some anxiousness and trepidation. But I think what they found, in fact, is that given the amount of time that I spent in that area, I developed a very good appreciation for what a wide continuum of criminal behavior there actually is, from youthful stupidity on the left to people who are true sociopaths on the right, and everything in between. And these are all individuals, and there's often a particular sentence or result suited to that individual. The goal, I tell people this when I sentence them all the time, that, look, I don't want to see you back here again. Your attorney certainly doesn't want to see you back here again, and the prosecutor doesn't want to see you back here again. We want to see you turn your life around and become a valuable and productive citizen. Having been a prosecutor, I'm going to be fair to the state if they have a case. They will get a fair hearing, and they'll get a fair result. So will the defense. That's what a judge is supposed to do. No one would suggest that I would come to this with the possibility of being a prosecutor on the bench.
Thank you.
Ms. O'Brien?
Thank you. Judge, we've heard from several of the other applicants that they are into the text of the law in a way that sounds very adamant and certain. I'm not sure what that means. I didn't hear you say that. Can you comment on maybe your interpretation of what that is and give us some insight about whether you would hold such a philosophy?
Well, obviously, I can't say what the other folks meant when they were here. I assume they're referring to textualism, strict constructionism, that sort of philosophy. I mean, I think it's correct that you start with the statute as a starting point in terms of your interpretation, or with the text of the Constitution, but obviously, if the statute's ambiguous, if there's a lack of clarity there are time-honored tools of statutory construction that have always been used by judges. The context, legislative history, if there is any, there's a wide variety of them. So, I mean, I can't say exactly what those folks meant, but I would assume that would be the case. But there have always been tools of statutory construction. There always will be. As far as I know, the court's always used those regardless of what side of the philosophical line that they might fall on.
Thank you. Mr. Hobach.
I have no questions. Thank you.
Mr. Spies.
Good afternoon, Judge.
Good afternoon.
First of all, I have a healthy appreciation for the type of work you do, having spent a couple of scintillating weeks in Scott County.
Indeed you did.
Where there were 4 or 5, sometimes 6 jury trials going on every day.
Yeah.
It's amazing. But that being said, one of the functions of the Supreme Court is providing a supervisory role, exercising a supervisory role of the district courts, and also providing support for the district court. And in what capacity do you think that the Supreme Court could improve in those functions, either as a supervisory body for the district courts or providing support for the district courts?
Right. Sometimes I think that's simplified to providing guidance in the opinions, but I think, as you know, their administrative role is much more vast than that. They establish the commissions that effectuate and sometimes amend the rules of the court. That's the most direct way. But the rules that govern the judicial branch generally and its employees come out of the court. Also, things such as the forms that are used by pro se litigants, which is something that I've referred to here in the past. I think that those are things that we need to greatly improve to make them more usable to pro se litigants. There's an explosion of self-represented litigation in the courts. It's coming whether we like it or not, but that's an area where I think the court has to do more. They're trying, but more has to be done. And I think if you don't have the experience of being a district court judge down where the rubber meets the road to see how these things are implemented and to deal with folks who are struggling to get through the system, struggling to deal with those forms, you're really kind of flying blind. I think that perspective is critical, in fact.
Thank you.
Ms. Locke.
No questions, thank you.
Mr. Bevel.
No questions.
Mr. Bloom.
No questions.
Mr. Goodman.
No questions.
Mr. Berger.
No questions.
Ms. Conover.
Judge Barrows, transitioning from the district court bench, where you are the sole decision maker, to an appellate court such as the Supreme Court, requires you to work with the other justices. How do you envision yourself handling substantive disagreements about the law with the panel if you would be appointed to the court? Some folks think dissents are bad. Some folks think dissents are part of the process. Just tell me a little bit about your thinking about how you would approach the differences you may have with your fellow justices if you're appointed.
Your conversation reminds me, or your comment reminds me of a conversation I had with Justice Cady and Justice Zager when they both, I think, in a way somewhat fondly looked back on the era when they could just make a decision and everybody had to go with it. Now they have to, and then they found themselves in a position where they had to get votes. I think, anytime you work in a group dynamic, you want to encourage a collegial atmosphere. The most important thing about that, obviously, is listening to people and hearing their argument. And really, that's the most important aspect of it. I think sometimes special concurrences and dissents can have a useful role, and of course, sometimes they later become the law. But I think respect is the critical thing, and listening to the other members of the bench.
Well, Judge Barrows, we are down to where we don't have time for another question, but we certainly thank you for being here today, and we wish you well. And thank you
very
for
much.
coming back.
Thank you, Your Honor.
Thank you.